The law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program's been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide information and resources that'll help you determine whether or not you need a lawyer. Perhaps will help you determine that you can actually handle some issues yourself. If you do need professional outside counsel, you'll be better prepared, and of course, as a result, so will the professional you select. Either way, of course, our hope is to help you save time, money, and achieve the best possible result. We want to welcome and thank once again Attorney David Bazar.
Thank you.
From the Bazar and Associates Law Firm in East Providence. They continue to support us, the issues that we tackle, and the insights that they bring, we greatly appreciate. So today, a few of the legal wrinkles on the minds of seniors, but not only seniors, and more importantly, how to treat those wrinkles. Guardianship, probate, as we started to speak about, and Medicaid can all be crises if you don't plan. However, if you do plan, it ends up presenting an opportunity. Most people know that if you have limited assets and low income, you need help for a nursing home or extended care, long-term living, you might be able to tap into Medicaid, but the issue is complicated. It certainly means when you talk about Medicaid that it's not just for seniors. Certainly there are those who are medically needy, needing Medicaid services, who are children and young adults, but we're going to focus on the estate part of it, as we started before. The rules of eligibility for Medicaid are complicated. We're going to take this and put it in a larger context, picking up where we had left off a while ago, talking about estate planning. So before we get into this, David, where does the idea of guardianship play into the bigger picture of estate planning and wills and probates before we get into Medicaid?
We've talked about estate planning before in the context of trusts and wills and probate of wills and moving assets from one generation to the next. And we also talked about powers of attorney and healthcare power of attorney and that type of thing. So the best thing a person can do is to have documents in place to avoid probate. Those are not only just trust, if you can do it through that way on the death and passing of assets, but while you're alive and the need for disability planning, I guess we could call it, if you need somebody to help you with financial issues or if you need someone to help make medical decisions, those documents were the powers of attorney and healthcare power of attorney. If you don't have those, then you're forced to turn to the probate court to have a guardian appointed to help you with the same issues that would have been helped through your selection of somebody through the documents that you created.
So does guardianship really pertain to you making a choice for yourself while you are still competent to do so? Or is that really just something that you set down so that when you pass, my children who need guardians, their things will be taken care of, their life is taken care of? Can you clarify that a little bit? Is it just elders?
Two different issues that you raise. One is on the planning side. Well, planning for who's going to watch after your children, if something happens, you can, in a document, a will, if you will, create at least to the court's the court appointment of it, someone who you prefer to be the guardian, that the probate court still has final say over who is going to get appointed. For example, if a husband and wife are divorced and the wife names her parents as guardians of the children in her will, but there's still a father, that's not going to necessarily defeat the father's right to have guardianship or care, custody, and control of his own children. But if there's a reason for the parents to be the guardians rather than the father who, perhaps in this hypothetical example, hasn't been involved in their lives for years, has no contact with them, doesn't pay child support, is behind on all of that, and really is sort of a stranger to the children, then perhaps by naming the parents, it gives them at least a leg in the door, so to speak, for the appointment of them being the guardians.
Okay, and just clarify one other term, conservatorship. What does that actually pertain to, and who needs that?
So when we talk about appointment of a guardian for a person, it can be for an adult, or as we were talking about before, children. There's a lot of different aspects to what a guardianship can be appointed for. It can be appointed for placement, residential decision-making for the ward, the person who's having the guardian appointed for them. It can be for medical decision-making purposes. It can be for social relationship purposes, who they are going to associate or not associate with. It can also be for money. So sometimes if someone needs someone appointed to look after the assets of a person, that can be called a conservatorship. You're trying to gather all their assets to make sure they're not being wasted. But it can also be called a guardianship if part of what you're doing is marshaling all the assets of the person and helping pay the bills and control what's being done with the income and assets of that ward.
Okay, you touched on a lot of different points. My understanding about a guardian is that they are only granted the powers that are necessary to accomplish whatever it is that isn't being taken care of or can't be taken care of by that person. Is that correct?
That is correct. And it's been an evolution and a bit of a change where someone was either appointed a guardian or they weren't. And sometimes there were just a few issues, as you say, that need to be taken care of. So a guardian can be appointed for the limited purpose of serving in those particular areas. So it may not be necessary to appoint a guardian over the property of the person, especially if there isn't any, because that creates other responsibilities for the guardian for reporting to the probate court and accounting of what's come in, what's gone out, what assets there are, what's been done with those assets, when it's not necessary. So the probate court judges' positions in most of these cases is, let's do the least detrimental, least required thing that a person needs to have their affairs taken care of.
Good, okay. So we're starting to talk about probate. Most people would like to avoid that. We started to talk about having an estate to do that. What's the best way to approach not only having an estate plan when you're old or ill, but the value in having an estate to help you plan for some eventualities?
Well, talking about the guardianship aspect of it, again, if you do the preparation before it's needed, and we can talk about other areas where you really can't, but if it's for disability or a particular point in time when you're here but you're not, so you can't really take care of your own affairs, you can plan for that by creating the documents we talked about, the power of attorney, the healthcare power of attorney, those types of things. There are times where a guardian needs to be appointed where there's no planning that can be done, and it's not necessarily for an older person. For example, there might be a child who's in the care, custody, and control, so to speak, of DCYF because of their family situation, and beyond that, their own disabilities, mental challenges or whatever it might be. And so DCYF can only help out to a certain point, and there's been a little change where it can go actually to 21 instead of 18. But between 18 and 21, the child is an adult, and it usually is in the best interest of that child to have a guardian appointed during that period of time so that somebody's in place to be able to deal with the issues that DCYF may be dealing with, or whoever DCYF has placed the child with, until age 21 comes and they no longer can be involved. Then the guardian's in place to be able to take over and help fill that role.
That's interesting, a new wrinkle. So when someone is doing, let's talk about the Medicaid situation. That is, as we generally understand it, for those who have very little income or few assets, but between that and the need to have an estate to avoid probate, let's get into that a little bit. You always tell someone, make a will.
Yeah.
fine. Durable powers, all the rest of that. So at what point do we plug into estate planning to deal with or anticipate the needs for long-term care
So,
and Medicaid?
Medicaid. So as you said, Medicaid is actually a welfare program. So to qualify for a welfare program, you have to have an asset and income test. Your assets can't exceed a certain amount, which is about $4,000, although some exceptions we can talk about. And your income is taken into consideration too. So Medicaid falls into the same category as AFDC welfare, the SNAP program, which used to be the food stamp program, and all of the other types of safety nets that we have set up in society to help people to make sure that they have at least a bare minimum standard of living. So the long-term care aspect of Medicaid, because Medicaid can also have medical benefit, as you mentioned earlier, provisions too. But the long-term care can be a nursing home situation. There are programs where we try to keep the person at home, but provide for some in-home help. And the benefit is the person gets to stay at home and it costs less money, theoretically, than a nursing home. So there are other aspects. Go ahead.
So does Medicaid provide an opportunity for someone to stay in their home if all they need is a little CNA, certified nursing assistant care, versus tubes and things that might mean they need real nursing assistance?
There is a possibility for that, absolutely. There's a program that allows people to stay in the home and have whatever help they need. And there's a really complicated formula that goes into how they determine what the help is and what they pay for versus what the person's copay would be in that. It's, again, income and asset based, but if you would qualify for staying in a nursing home, but for the fact that you would rather be at home and it would cost less money and we can put a program together to keep you at home, then yes, that can happen.
Good to know. This issue of Medicaid is very complex. I know we've started to talk about estate planning as a way to take care of your assets moving forward. When it comes to Medicaid, very few people have to worry about the huge issue of federal and estate taxes with that many zeros. But when it comes to Medicaid, that's the other side of the scale. Mm-hmm. How do you anticipate that using trusts or
So let's just say somebody came in to see you and they were healthy and getting to retirement age, but still young. You would probably, and they come in and they say, well, we're really concerned about nursing homes, because that's how people usually phrase it. It's, I'm concerned about having to go to a nursing home, and the nursing home or the state takes everything I have.
Yes.
And so you have to look at the whole picture as you talk through that person, and it's exactly the explanation that you just talked about. Do you want to make yourself poor? Because you have to be poor to qualify for Medicaid. And for most people at that stage of life, it's not a real answer. It's not really the right answer for most people at that stage of life. There's no prognosis that they're likely to be in a nursing home soon. They've got a lot of money, you know, and comparatively speaking, and they really are thinking about nursing home. That might be a little early. They might be more in a position, and I'm thinking particularly of cases that I've been involved with where they may have significant amounts of money, and they probably would be better off buying long-term care insurance, which comes in many different forms now. And the old complaint about that was, I bought that insurance, I never used it, and it was of no value. Now you can buy it and have it combined in with a life insurance component, so that if you never use it, there might be some payback in life insurance or some other form of payback or annuity that might be available. So if you have a client who comes in who has significant enough assets, they're young enough, and it's not really that time to start saying you need to make yourself poor so you will qualify for Medicaid, then you give them a different advice. Sometimes they don't want to listen to that, and yes, there are different things you can do, and yes, of course, people always come in with the biggest concern, the 5-year look-back period, because if you give away assets to make yourself poor to qualify for Medicaid, Medicaid's going to say, well, did you do that because it was part of estate planning, or did you do that because you knew you were going to be in a nursing home and you wanted to be able to qualify for help? And they use this 5-year look-back period because the assumption is, well, if you gave away something 5 years in advance of needing to go into a nursing home, you probably weren't giving it away at that point in your life to qualify for nursing home aid, Medicaid.
Is it true with that 5-year look back, David, that you would have had to have given away or transferred that asset, however, we can get into that in a minute, but they can't begin to look at that look back period until you apply for Medicaid.
Correct.
So if someone's 42 and says, gee, David, I want to plan for this, they're not applying for Medicaid that next week.
Right.
It's down the road. So
Right.
how does that actually work?
Well, that's the point. So the 42, the person approaching retirement that's in really good health, and they come in and they say, I really don't need a lot, and I want to pass what I have to my children now. And yes, it may help Medicaid down the road if you ever need to apply for Medicaid down the road if you ever need it, but this is what I want to do at my stage in life now. That's the whole point, is you're not planning on applying for Medicaid when you gave this money away. You gave it away long in advance of that, way beyond the 5 years, and it wasn't, part of the reason may have been, hey, I'll be qualified if I ever need it, but you're not doing it to qualify.
Yes.
If you give away the money to qualify because you know you're going to a nursing home, you are 100% correct. The 5-year clock starts ticking, looking back on the day you apply. So if you're 42, you give it away, and now you're 62, it was 20 years ago. It had nothing to do with that application.
So I understand, we've read these terrible stories about how people play the game. They're unethical, illegal, or whatever. But there was a time apparently where someone would consider giving their house to their child and said that they sold it to them or whatever, but they didn't, and then the kids will sell the house out from under them and all these other stories. And other times still where the person who gave the house away was supposed to be doing it with the understanding that they would be living there, and in fact they never did. So Medicaid, I guess, looked unfavorably upon that because it wasn't just
Right.
done in the proper terms. So when you're doing estate planning, 42, 52, someone's that age, do you have them put things in a trust? How do you strategically, reasonably, and ethically deal with the transfer or how you rename assets? How do you deal with that, David?
Yeah, so my take on it is, yes, there are things that you can do to help qualify you for Medicaid. Most cases that I'm involved with are not at that stage, and they're not about doing the, I think you call them tricks.
Yes, or whatever.
Whatever you want to call them. The things to qualify someone for Medicaid, it's usually estate planning. And so to take an example of one of the things you talked about, the life estate deed, where you do want to put your children on the property, but retain the ownership of the property. And that is a technique that's often used by clients who come in and say, I don't want to pay for a trust. I don't want to go to that expense. I don't have enough assets to really do that, but I don't want my property to go through probate. And one of the things they think of is, I want to be able to transfer my property to my children on our death without having to have probate. It's an absolute reasonable thing to do once you understand the consequences of doing that, which are you are adding someone to your property that you have to trust and be aware that if they have an accident or something, can that affect the property ownership? Maybe, maybe not. They don't own it till the future, but what if they get divorced? Do they have an asset that was given to them? Is that part of the divorce? All of the things that you would tell somebody that is of a concern that you can protect in a trust, you can't protect with a life estate deed, but they need to know that. But it is a technique that can be used. And it was also a technique that some people would use for Medicaid planning. Now, the thing you need to know is the house, usually in Rhode Island, different in Massachusetts, is an exempt asset for Medicaid
Explain
planning.
that.
So when they look at your assets and they say you can have only $4,000, most people who go into a nursing home when they're in Rhode Island, when you fill out the form, say, do you intend to return home? Because everyone would like to return home. You say you intend to return home. And so they don't make you sell that asset, and it's not a disqualifying asset in terms of what you're allowed to own. Now, if you gave it away through a portion of it, through the life estate deed, well then that has to be reported, and it's a gift, and if it's within the 5 years, it can be an issue. That's a little change into how they look at it now as how they used to look at it, but it's something that you have to consider. Where are you in your life? What's the purpose of doing that? And what stage are you in terms of ever thinking about being in a nursing home?
And you said that may be different in Massachusetts. So people, if they're looking to plan ahead, they certainly, this is not one of the do-it-yourself issues, I suspect.
Yeah.
That if those, and things are changing, if not every week, at least every year, and worthwhile to look at. So is this a good time perhaps to discuss, some will want to plan maybe Medicaid planning, but maybe they may think that buying that life insurance or some sort of long-term care insurance, there are differences in what each will cover, and we certainly don't have the time or wherewithal to do the play-by-play and the point-counterpoint. Would an estate planner review that with someone typically?
Yeah.
So that you could say, well, you may not need this, you might need this, and help evaluate that. Is that a reasonable thing to expect?
So let's say the client comes in to me, and as Larry mentioned before, we ask, well, what are your goals? What are you trying to do with this plan? And many times, protect the assets from the nursing home is one of those things. And like I said, we look at the whole picture, and if somebody comes in and they have significant income and they have significant assets, but they're not wealthy enough, and who is really, to be able to sustain the expense of a long-term placement in a nursing home, that's a discussion where you have enough money to buy some long-term care protection. And I don't sell it, I don't have anything to do with it, but I would recommend people who do, and tell that there are a number of different products that might help depending on your situation. Life insurance, again, is part of estate planning, and if you have someone with significant assets, but they need to have some liquidity because maybe it's a family business or something, again, life insurance might be a part of that plan. And again, we don't sell it, but we know people who are respectable in those fields that we could refer someone to, or we meet with someone that the client has so everyone's on the same page.
Reasonable to at least mention in this that too is a complex issue that sometimes makes it difficult to know what to do if you're expected to live 8.7 more years versus 9.5 and you fall short of or longer than, and how that plays out. But that certainly says there's reason to explore that to the extent that you're able to plan and plan ahead for it.
You're right. Every situation is going to be somewhat different.
Yes.
Because it's what are the assets, what are the income, what are the players, what is the family dynamic, what's the situation. Some people have come in and said to me, and I totally understand where they're coming from. I took care of my mother and father. I have 3 children. I am not going to do anything to make plans to be in a nursing home. My children are going to take care of me, and if not, then all of my money can go to pay for that.
Reasonable to think about. Let's address the other side of it. For example, someone chooses not to plan Medicaid. Need to be tapping into the Medicaid system, which I guess we need to point out. There's Medicare and Medicaid. Right. There's federal and state. The laws of eligibility change with each state and change, I guess, yearly. But if you are married and you need to be in the nursing home and you need to have Medicaid and you are eligible for it, is it true that the spouse who's still in the home, they get to stay in the home? They're not going to, the state is not going to take that away. They may try to recover it afterwards, but that person's still safe in the home, right?
So yes, but those are the situations now where it really is important to speak to an attorney who knows a bit about this because, or more than a bit, because the community spouse is what that person would be called, has certain rights, and yes, you are correct. If they own a house, tenants by the entireties or whatever, both names, and or even not, the wife lives there, and it's the state is not going to say, sell the house so that we can pay for the spouse in the nursing home. But there are other assets that are probably in play and need to be discussed and talked about. So it's really wise to speak to an attorney to see what the assets are, what you can do with those assets, because again, certain assets aren't countable if they're done properly. A lot of folks' biggest assets are the home and the retirement account. And if the retirement account is treated properly, that won't be counted as an asset, but rather as income and can be protected as well.
Good to know. I know you had mentioned earlier that there are various assets that don't count. They're not going to make you sell your furniture and the antique so that you can be paid.
Yep.
But there's quite a complex set of issues involved with how they try to recover, and even occasions apparently when they won't try to recover.
Right.
If it's going to cause some undue hardship, or there's a child who's disabled.
Yes. Yes, those are all issues that you need to talk to a professional about, but you're 100% correct in broad brush strokes. If there's a spouse or a disabled child in the home after the person has passed, they're not going to put that person out of the home, generally speaking. There are other areas where they won't try to recover once the person's died. If it goes through probate, you know, and there's no spouse in the house, so to speak, that's a point in time where they may force the issue. If there's anything in the estate of value, they're going to try to get paid back. But there are a lot of exceptions to that rule that you would need to explore.
Mostly when you have children, even if you've done no other planning, would you say that this issue about what you do with your house and what's going forward, is that they often say that your house is your single best asset.
Yeah.
Is that really true in this case too, David?
Yeah, well, I think for most people it is the most important asset, and like I said, the retirement accounts and the houses are usually the largest assets.
Do you usually think about annuities when you're dealing with this in terms of Medicaid planning too? That's
Yes.
part of that in addition to what might be long-term insurance?
Correct, long-term insurance and annuitizing the retirement account so that it's income and not an asset that's disqualifying.
And at all times, it's still a 5-year look back? Is that a point that almost all states, or is that?
Yeah, I'm pretty sure that it's pretty consistent, so I would say yes.
We certainly have covered quite a few topics here. We hope that these topics that we've touched on have been helpful to you in your planning. If you need to have additional outside counsel, at least we hope that you'll be better prepared than you were prior to this segment. We think that you should stay tuned to The Law Matters because the law matters to you. We'll see you next time.